today we're going to be talking about recruiting for H-2B workers and some employer hiring obligations. But yeah, again, you can ask questions related or unrelated to that topic. It doesn't matter. But well, with that in mind, let's go ahead and get started here. All right. Well, we're going to be talking about, recruiting for H-2B workers and hiring obligations. Not going to be a real long PowerPoint, so we should have plenty of time for Q&As if folks have questions. Part of the H-2B filing process is demonstrating that the employer, the petitioning employer, did not adversely affect the U.S. Job market, basically. So you gotta demonstrate through the application process that you're not adversely affecting the wages and working condition of similarly employed U.S. workers. And so to do this, you file a job order. The job order is the first technical step in the H-2B process. One thing that I think people get confused about with H-2B visas, and same thing with H-2A visas, is the actual point of the program is to allow employers to backfill their domestic workforce with a foreign workforce. And so the application process with H-2B filings, the actual point is to try to hire U.S. workers. Now, of course, we all know that the end result is not usually successful and that you can't find U.S. workers. That's why you're petitioning for H-2B people to begin with. But the actual point is to get your job out there to any able, willing, and qualified U.S. applicants that are willing to apply for the position. And your job order does just that. So the job order is extremely important. You want to make sure that your job order has the proper wage rate that you actually pay your people. And of course, you can't pay less than the prevailing wage determination to your H-2B workers or to similarly employed U.S. workers. So something to be aware of. Make sure it actually has your correct anticipated hours, correct overtime wage rate, and then the actual the working conditions and the correct job occupation and job duties that the people are going to be performing. Those are all very important things to have in your job order because you want to properly advise U.S. applicants or prospective U.S. applicants about what the job actually entails. So it's an important thing. Make sure to actually read your job order before it gets posted to the state workforce agency. Make sure the contact information is correct so that any qualified U.S. applicants can reach you. And just as a reminder, H-2B filings are for temporary or seasonal needs. So there's various ways that you can meet this. One-time occurrence need, seasonal, peak load, or intermittent need. Whenever I'm referring to the U.S. workers, this is for the actual period of need certified on the application. So your wages of your domestic workforce can be affected by your use of H-2B people. That would be limited to within the actual certification dates. So, and then as a reminder, if you didn't know this, that's fine too, but the H-2B program is numerically capped. There's a cap of 66,000 visas. The way the government allocates these is based off the government's fiscal year. So the first half of the fiscal year starts on October 1st for the government. It's the first day of the fiscal year. And so they allocate half of the H-2B visas for that time for work that starts on October 1st and runs through March 30th or 31st. I think that March, yeah, okay. Yeah, March has the 31st. I believe it. Through March 31st. And the October cap historically has been significantly less competitive than the April cap, although it is getting much more competitive. It used to not get hit at all, and then it started getting hit, but it wouldn't really get hit unless you had a date of need that was like in March. Then it started getting hit if you had a date of need that was in February. Then it jumped up to the beginning of January. Now we're at the middle of November. So October 1st is certainly getting more competitive, but those visas are available for employers that have a peak load need or a need that starts during that time. Excuse me, sorry. You see, and it makes logical sense that the April 1st cap would be more competitive than the October 1st cap There we go. Now I think I'm talking like a normal person. Okay. Because April 1st is when it's the summertime. It's the spring, summer, and it covers the fall. And so there's just more work that gets busier during that time. So think hospitality, a lot of hospitality industry, a lot in the landscaping and construction industries, and the seafood processing. That's kind of like the peak need is during that time, not so much on the October 1st end. And during the October 1st end, what you see is a lot of ski resorts, snow removal, holiday light installation, those types of people. Okay, now, as it relates to H-2B recruitment, there is a potential opportunity to recruit H-2B cap exempt workers. And this is great if you can make it work. So, let's say that you run a landscaping company and your brother runs a holiday light company, or maybe you run both. And so you need workers badly from April through, or let's say from March through November. Let's say that's your season. You need people from March through November, and your brother and his lighting installation and company need workers from December through February. Well, y'all could transfer your workers back and forth for up to 3 years, and those would not be cap subject workers. They would be cap exempt workers. And so if there is a possibility to work with another employer to change, like to have your workforce go back and forth for a period of time, it's a great way for both of you to avoid potential cap issues. So I think we're going to start seeing more and more of that, the more competitive this visa becomes. So it's a good thing, a very, very good thing. So what is a cap exempt workers? It's one that's extending their stay currently in the United States on the H-2B status, and it's extending their stay, changing employers, or changing the terms and conditions of their employment. That last one doesn't really help you that much, but the two that could be extending your stay and changing of employers. So an extended stay situation would be, let's say that I own a landscaping and a holiday light installation company. I own both of them. I could have H-2B workers for the holiday light installation, then I could have H-2B workers for the landscaping work. And I could just extend their stay for up to 3 consecutive, or for up to 3 years, and then need to go home for 90 days, and then we can do the song and dance again. The change employers route would be if I own the landscaping company and my brother owns the holiday light installation company, and we just want to transfer workers back and forth during our respective peak seasons. That's fine too. And that's cap exempt. The other option is H-2B workers who have previously been counted against the cap in the same fiscal year, and the proposed employment begins is also cap exempt if the employer petitioned after the cap is full. So let's say, for example, a worker came in on a certification that started October 1st, which is the first half of the fiscal year. That worker, the worker, is not subject to the cap again until the following October. So let's say that employee worked from October through December, and then that employee went back home to Mexico. That employee could come back up into the United States to work on any properly petitioned H-2B filing, because they're cap exempt, and they would be cap exempt until the following October. So that's another good way to do it. The other thing that can help you with recruitment, especially as cap increases become more competitive, which, just so we're clear, what happens with the cap increase? With the cap increase, that Congress authorizes the Department of Homeland Security to issue additional visas for H-2B petitioners, and the qualifying people would be people that have had an H-2B visa in one of the prior 3 fiscal years, or people from the Northern Triangle countries, which are Honduras, Guatemala, and El Salvador. So there is a benefit to recruiting from these areas, because by recruiting from these areas, you're not competing with all the other people that are trying to get the returning worker the returning workers, because most of them come from Mexico still. And a lot of times, if you're an employer and you've been involved in this program for a while, the returning worker one still makes sense. And right now, we haven't seen the competitiveness of the cap increase be so substantial that it would interfere with your ability to get workers under the cap increase, at least not yet. At least we haven't seen it, but we also get our cap increase filings out the same day that they allow us to. So I don't know if you hold on to it, maybe it's a problem, but we haven't ever run into the issue. Northern Triangle countries, though, this is a great option if you don't have access to returning workers. So we recruit returning workers from Mexico a lot of times. But let's say hypothetically we couldn't find someone. Well, we might look to Honduras, Guatemala, or El Salvador because we don't have to worry about have they had a visa in the prior 3 years. We just need to find someone that actually meets the requirements of the position. And so it's a good place to look, and those tend to be less competitive. The government's issued 6,500 visas a year just for those countries. And so, yeah, no, anyways, good. And we can help recruit in those countries as well if you are looking for help. So whenever you're hiring H-2B workers, you need to specify any minimum productive standards that the workers need to meet to retain employment. And this is something that people make the mistake of all the time, is they improperly fire H-2B people. This is another reason why your job order is so important, because your job order should specify the conditions of the job, meaning also the production standards that the workers need to meet, so that if you do fire them, you're able to fire them and you can do it without substantial consequence. And so that's an important thing. You also need to abide by the 3/4 guarantee, although right now the Department of Labor is not enforcing the 3/4 guarantee, but it is a good thing to abide by. It's basically 3/4 hours on a rolling 12-week basis under H-2B that need to be offered to the workers. Continue to abide by it because the Department of Labor could start enforcing it at any time. It's just that it has been excluded from enforcement for a few years now. The employer must not receive any payments from the prospective workers or any activity in the application process. So this is also one that people run into all the time. It's not even necessarily the employer. This actually should probably read, the employee must not pay for any activity related to the application process. Now they can pay for it initially and then be reimbursed by the employer. But what happens in the H-2A, H-2B world all the time is employers working with some non-reputable or even semi-reputable agency in Mexico to process their workers and to recruit their workers. And let's say the agency hasn't done a good job, doesn't have a bunch of checks and balances in place to ensure that their people are not paying for or not getting paid by the employees for the opportunity to work on the visa. So let's say that you bring in 50 people and each of your 50 people pay your recruiter $1,000 just to get on the list. And this happens all the time. So your recruiter made $50,000 off of your people. And your workers come into the United States, and in doing so, you learn that the recruiter was paid $1,000 by each of these guys. Well, you can't fire the workers for it, but you also owe all your workers $1,000. There's no knowledge component to this. There's a strict liability issue. If your workers and the Department of Labor were able to prove it, if the workers paid for the opportunity to work on an H-2B visa and the Department of Labor is able to prove it, you would be required to pay back all the money that they paid for their recruitment. It's a very important point. It's something to protect yourself against. Also, make sure whenever your workers get here, you properly onboard them, meaning you make sure they get a social security number, make sure they complete all the required tax documents, make sure that you reimburse them for their travel expenses. I always prefer people do this within the first week because you can potentially run into Fair Labor Standards Act issues if you don't pay for their inbound transportation, hotel costs, meal costs, embassy fees, border crossing fees, all those sorts of things. So make sure you're paying that back right away. And then employers are required to provide the required tools and equipment to perform the duties as well. So if you're requiring you got to use a shovel to perform your work. Well, you can't require the employees to buy their own shovels. You got to provide the shovels. So you got to provide all the necessary tools and equipment to perform the work. So what's important here is that you find a group of skilled, trustworthy workers, ones that you know aren't paying someone for the opportunity to be recruited, and you want to build a good relationship with these people, because you do want the same people to come back year after year. You spend money and resources training these people to do work the way that you want it done. And so you want the people to come back year after year. The best way to do that is to build a good relationship with the people so that they want to come back and work for you year after year. And for our clients, we generally see a very high retention rate of employees every year, but it's important. So, and here are some good ways to do that. If housing is not provided as disclosed in the job order, it's great for employers to help coordinate lodging at least for the first week, because this helps the employees significantly. From their perspective, they're going from their foreign country to the United States, and it's intimidating. And if they get here and they don't know where they're going, it's way worse. So help coordinate lodging for the first week. It's good to also prepare some of the essentials for the first week. Food, toilet paper, soap, cookware makes the workers feel very, very welcomed. And it's a great way to start off your relationship with your workers on a good foot. And then again, reimburse the travel expenses, provide transportation to and from the work site, weekly transportation to the grocery store. All these things just make life a lot easier with these people. Easier for them, makes them want to come back, because they will have heard from their friends what it was like where they were working. And you want to be on par or better than those other people. You want to have a company where you get the best talent because you treat them well. And I can tell you, it does help with your retention rate. It also helps with your production. So it actually impacts your bottom line in a positive way by doing a bunch of the little things. And then make sure to review the workers' benefits with the workers. A lot of times, insurance providers and such will require you to actually provide insurance just based off of the amount of time that the workers are here. And so make sure to check with your policy provider before your workers arrive so that you can have the discussion with your workers whenever they do arrive. But that's all I got for the PowerPoint. Let me check if there's any questions here. So if you have any questions that you want answered here, you can put them right here in the Q&A. Happy to answer any of those. I also have the chat up, so if you do have questions that pop up, you can just put them in there, and we will be I'll be happy to answer any of them that you have. Can a business submit two 9142B applications consecutively, one for workers from Mexico and one for workers from the Northern Triangle countries? Can those two applications use the same prevailing wage determination? So you want to do that at the 9142B stage. You do that at the I-129 stage. So you would file one prevailing wage determination, one 9142B, and then two separate I-129s, one for Northern Triangle countries, one for returning workers from Mexico. That's a great question. But there is a specific provision in the regulations that says that you can't file multiple applications, separate multiple applications for the same job opportunity. And so you would have to file one prevailing wage determination because you're performing the same work in the same area of intended employment, one 9142B, and then two separate I-129s. And you can do that. I guess one point on the I-129s, the total number of workers requested on the I-129s couldn't exceed the number petitioned for on the 9142B. So let's say that you petitioned for 20 people. You couldn't file one I-129 for 20 people from Mexico and one I-129 for 20 people from the Northern Triangle countries. You'd have to do one for 10 people, one for 10 people, one for 18, one for 2, whatever. You just couldn't exceed the number 20. Do you think the midterm election results may positively impact the H-2B program in the future? Specifically, the gridlock we have been experiencing in the past, example, releasing additional visas late. No, I don't think that the midterm election results are going to be helpful to H-2B. I don't. I think that you're likely going to see, I mean, you had gridlock, but the gridlock didn't result in especially over the last 2 years, didn't result in the visas being issued late. They were issued as part of a budget bill, which was a filibuster-proof bill. So all the Democrats need for the last 2 years was to push a bill because they had the majority in the House, they had the majority in the Senate. The Senate couldn't filibuster it because it's not part of it's a filibuster-proof bill. The visa allocation was part of that, and so I think if anything, there's gonna be more gridlock, not less gridlock, because now the Democrats are going to control the House of Representatives. So, in that way, the Republicans could hold it up. Okay, so the question is, what happens if you have a worker, an H-2B worker, then H-2B worker is recruiting your other H-2B workers, and you find out that your H-2B worker is not a recruiter because it's not outside your company, it's just internal referrals. But they are paying your worker. Can you be penalized? Can you be charged for the payment of those workers, the reimbursement of them for the workers being given the opportunity to be put on the list by your other H-2B worker? And the answer is yes. That's no different than if it was a recruiter. The Department of Labor looks at exactly the same. This question is, we're a construction company with some prevailing jobs and non-prevailing jobs. Basically, wages vary per job assignment. And so I'm assuming, you can correct me if I'm wrong in the Q&A, but I'm assuming that this is like Davis-Bacon jobs where there's a set federal prevailing wage in that area to perform that work. It's government subsidized work, and you pay them more based off of which type of work they're performing at that time. So if I'm wrong about that, you can correct me in the Q&A box. But yeah, so the way that it works, whenever you're filing for like Davis-Bacon jobs, for example, you would file your prevailing wage determination. And then if you have different wage rates for the different the different work that your workers are performing. So let's say that you do construction and framing work and plumbing work. So construction, framing, plumbing. I mean, carpentry. Okay, sorry. Concrete, framing, plumbing. There we go. I don't know what's so difficult about that. And you put all of those job duties on your prevailing wage determination, as you should. The Department of Labor would assign you a prevailing wage that is equal to the highest of those occupation codes, probably the plumbing or the concrete, I would guess. And then the normal circumstances, the actual Davis-Bacon wage is a lot higher than the prevailing wage that you get from the Department of Labor. So what you would do is you would file your job order, and on your job order, you would say wage rate is this while being performed this wage rate or this job. So during framing, they're getting paid this. That number still has to be above the issued prevailing wage determination. You do the same thing with concrete and with plumbing. So you could pay them different wage rates based off of which type of work they're performing, but none of them could go below the prevailing wage determination. And you would need to mention that on your job order. That's why your job order is so important. Okay, cool. Well, we got no other questions. We can just get back to it, but I certainly appreciate everyone participating. I appreciate all the questions. The engagement's very, very helpful for these things. So if y'all have any other questions, feel free to reach out to us. You can contact us at intake@farmerlawpc.com. Otherwise, we will see y'all next time. Thanks, everyone.